Thank you so much. I appreciate all of your testimony, and sorry that I missed some of the opening statements. Let's go right into it now. We'll go back and forth between Republicans and Democrats in order of seniority and arrival, and we'll begin with that now with 5-minute rounds. Commissioner Meador, I'd like to go to you first. How do you think principled and consistent antitrust enforcement can diminish, or in some cases even obviate, the need for prescriptive regulation?
Thank you. It's an excellent question. The two are closely connected. I was thrilled to hear other witnesses highlight this, as well as your remarks and Ranking Member Booker's. When we have robust, strong antitrust enforcement, that's what helps maintain competitive free markets. Regulation is at the opposite end of the spectrum. That typically comes in when there's been a market failure. And one of the purposes of strong antitrust enforcement is to prevent those market failures. And so I think it's critically important that we maintain strong enforcement. You know, we hear about companies today that like to brag, saying that they can move fast and break things. But the FTC will move fast and break things up. And if their conduct harms competition, we will step in, because antitrust enforcement today prevents the need for regulation tomorrow.
Right. And that's often true, especially if what's being broken up is being broken up because it's anti-competitive, rather than because it's big simply as such, or for some other reason. Mr. Alford, your testimony describes an alliance between big government and big business, one that uses the rulemaking process rather deliberately in order to place barriers to entry into that marketplace. In other words, it's one thing if regulations have the incidental effect of creating a moat, an anti-competitive moat around market incumbents. It's quite another thing when that is the design, when it's the feature rather than a bug. What can be done to prevent this sort of thing going forward?
Yeah, thank you for your question. Again, as you suggest, different regulations have different purposes, and I think the kinds of regulations that we should be the most concerned about are the ones where there is agency capture or where there is corporate lobbyists that are simply trying to increase the barriers to entry for other competitors. Often, the scenario in which that happens are large companies, big ag, big tech, big pharma, can raise barriers to entry and accessibility to the market for the lower, small and medium-sized companies. And there's a whole variety of different ways to prevent the problem. It depends if you're asking about going forward to prevent future such regulations or going backward to try to undo some of the previous ones. Our focus has been on trying to undo some of the anti-competitive regulations that have been enacted that fall into that category, where there has been agency capture or laws that are passed because of corporate lobbying. In terms of going forward, obviously, much of the problem should be greater transparency and recognition about the influence of these sorts of lobbying efforts, about what the purpose of the laws are. Very often, if you read between the lines to try to really drill down, they have to make up a reason why this is in the public interest, but it very often is not really a credible argument. I've seen that in numerous occasions. So much of the effort, I think, would be on trying to have regulations, agencies and Congress be sensitive about what's the true purpose of what they're trying to accomplish.
Right. I suppose one approach that one could take, at least prospectively, would be a reform like the REINS Act, which would require Congress, with regard to major rules, to be the ultimate decision-making authority on whether to propose it as new legislation. Article 1, Section 7 certainly tends to contemplate that you can't make or amend federal law without following that process. That would at least allow these considerations to be undertaken. Professor Francis, your testimony highlights some of the problems with licensing, occupational licensing recognition, the barriers that some of those things provide, particularly to military families who, by virtue of their military service, frequently have to move from one place to another. Most of these occupational licensing regimes, of course, are creatures of state law, not federal. So what steps do you think can appropriately be taken at the federal level in order to diminish this problem, either by encouraging states to reduce unnecessary licensing burdens without compromising quality or safety, or otherwise?
I think, Mr. Chairman, that's exactly the key question. Everyone recognizes the policy problem. What are we going to do about it? And while it's true that these systems are created by state law, the problem, at least the one we're talking about today, is distinctively a congressional concern. It's the impact on interstate commerce, and specifically the borders that workers and their families, both in and outside of our military, face when they try to exercise that sacred constitutional freedom to enjoy open and competitive interstate labor markets. So with that in mind, I think there's a spectrum. At the mildest end, you could imagine federal incentives that encourage but don't require states to adopt interstate recognition programs, either in specific areas, specific professions, or more generally. Cranking up the intervention a little bit, you could imagine a federally operated but voluntary for states recognition system, perhaps operated by the Department of Labor or the FTC, where individual states can notify the Department of Labor of their intention to participate in the federal program. And by doing so, they get mutual licensing recognition with any other state that chooses to participate. So again, that's the federal government as a facilitator, not as a director. One more notch along the spectrum, you could imagine federal licensing of some professions. Might not want to do that in every case, but across the board, you can see occupations where it wouldn't be crazy to imagine the Department of Labor or perhaps some other branch of the government establishing perfectly reasonable requirements and giving workers the freedom to apply for an interstate federal license, maybe even a federal bar exam, recognizing there are plenty of attorneys in the United States who only practice in federal courts. Finally, at the far end of the spectrum, you could imagine Congress really leaning in to protecting interstate commerce and labor and creating a mandate, creating a federal right to work across state lines that to the extent you've obtained a license in an individual state, that provides you with a federal freedom to work in any state that has equal or lower barriers to entry. That would be a remarkable intervention that would concretely do a lot of good for a lot of people.
Yeah, those are great points. And you've got me thinking. I mean, when you refer to the Commerce Clause interest at stake, there are existing judicial remedies, at least in theory, available for circumstances where a state discriminates either facially or in effect on a product, here a service, based on its origin or destination out of state or outside the United States. Typically, you're going to face a pretty tough battle if it facially discriminates, but you might also face another battle, and there might be a judicial remedy, even in the absence of facial discrimination, if you can show that the putative non-discriminatory benefits are substantially outweighed by a detrimental effect on the ability to deliver that service from across state lines. Now, that judicial remedy tends to be pretty hard to come by, but I think what you're suggesting is that federal legislation building on those could change some of that difficulty in a way that is compatible with federalism.
I couldn't agree more. So I take your first observation to be, wait a minute, don't we have a Supreme Court created, long settled, dormant Commerce Clause doctrine that is supposed to guarantee to every citizen of the United States and every person who's working in the economy the freedom to be free from state level or local protectionism and discrimination? You are exactly right, and I think the failure to recognize licenses at the state border raises serious problems under the Dormant Commerce Clause. That's actually the next academic project that I'm planning to pick up.
Excellent.
But access to litigation isn't a practical option for everybody. These licensing regimes don't just apply to, high-paid doctors and lawyers. We're also talking about an astonishing array of professions. We're talking about plumbers. We're talking about personal trainers. We're talking about landscape gardeners. I'm not sure it's practical to hope in a meaningful way that those folks are all going to be able to litigate their way through to interstate commerce, recognizing also that there has been a pretty striking tradition of judicial skepticism of this Dormant Commerce Clause doctrine in a way that I actually think runs right in the face of the original meaning and expectation of the way the Commerce Clause was going to operate on behalf of American workers. So while I think the Dormant Commerce Clause should be doing exactly this work, that is not the experience on the ground. It's been clear for decades, and that's why I think affirmative congressional leadership would be so valuable here.
Right, well, particularly for poor middle-class Americans. I mean, it's one thing if you represent a large industry group and can afford to litigate these difficult to litigate, under these difficult to litigate standards. But we should look into that. Anyway, thank you for looking into this, and thanks for plugging the Dormant Commerce Clause. In my hometown of Provo, Utah, we speak of little else. Senator Booker.
Mr. Chairman, may I suggest, being that you and I are here for the duration and love nothing more than discussing the Dormant Commerce Clause, that we allow Senator Blumenthal to go first,